Birthright citizenship. I have discussed this a few times in my radio career. I think 2009, maybe it was 2010, once or twice since then. And unfortunately, I had to sit and watch on TV while I was in California so-called experts tell us, and former Bush appointees and a former Superior Court judge in New Jersey tell us that the Constitution embraces birthright citizenship. And there's not a damn thing we can do about it. Well, that, of course, is completely false. And I don't know why people who call themselves constitutionalists swerve back and forth, lurch from the Constitution to Supreme Court decisions and back and forth. First, let's figure out what the Constitution says. And I see our senior legal analyst friend, he is a friend of mine, Napolitano, is all over the place, and he's wrong, as are many, many other so-called experts. I've actually spent my life on the Constitution. I wasn't a Superior Court judge in New Jersey. I wasn't a professor for donuts and coffee at Schmagegi University or what have you. And this is one of the areas I have pored over the decades. And yet nobody did a better job at explaining this than Professor Edward Erler, who I've talked about over the years. And he's a professor at California State University. He was also at the Claremont Institute, senior fellow there. But more than that, he happens to be right. And he testified before a subcommittee of Congress many years ago, almost 20 years ago, and he set forth the case. Now, he's not the only one. Professor Thomas West has. Lino Graglia has, professor at the University of Texas Law School. But even more than them, the framers of the Constitution set forth the basic law, and then we have, after the Civil War, 3 amendments to the Constitution, the 13th, 14th, and 15th, called the Civil War Amendments. And we know pretty much what occurred. Professor Erler was testifying. He said, it's my considered opinion Congress has the authority under Section 5 of the 4th Amendment to define the jurisdiction of the United States, of the 14th Amendment, of course. Indeed, it is my contention that Congress has exercised that power on many occasions, most recently in the Immigration Reform and Control Act of 1986. And I would say they also exercised it with the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. He points out Senator Jacob Howard. You are now going to know more than anybody else, ladies and gentlemen. You know, one of the things I find when I sign books, and it's good to do it because I get to talk to so many of you, people say, Mark, your show is different because you really get into the substance. Now, we have fun. Don't get me wrong. We do our thing too. But we do really get into the substance. It's one thing to say, yeah. Obviously, the Constitution doesn't provide that. That's not enough. That's not enough. So when you're in a debate format or a political format or a classroom format or this format, you need to back it up. And that's what we do here. We back it up. Senator Jacob Howard, the author of the Citizenship Clause in the 14th Amendment, he spoke. He told us what he meant. He defined who would fall within the, quote, jurisdiction of the United States, unquote. Ready? Quote, every person born within the limits of the United States and subject to their jurisdiction, meaning the states, their jurisdiction, is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. It settles the great question of citizenship and removes all doubt as to what persons are or are not citizens of the United States. This has long been a great issue in the jurisprudence and legislation of this country. Mr. Call Screener, Mr. Producer, you understand that, right? Is it not plain English? Is he not as clear as can be? That it does not include aliens, it does not include foreigners, it does not include families or with ambassadors or foreign ministers. So the author of Citizenship Clause intended to count foreigners, aliens, and those born to ambassadors, foreign ministers as outside the jurisdiction of the United States. That's Senator Jacob Howard. He knew, as his reference to natural law indicates, that the Republican basis, little r Republican basis for citizenship, is consent. Consent of the country. You can't self-immigrate. You can't claim jurisdiction because you happen to walk into the United States. Senator Lyman Trumbull, chairman of the Judiciary Committee and a powerful supporter of the 14th Amendment, remarked on May 30th, 1866, that the jurisdiction clause includes those, quote, not owing allegiance to anybody else. It's only those persons, I'm quoting, who come completely within our jurisdiction, who are subject to our laws, that we think of making citizens, and there can be no objection to the proposition that such persons should be citizens. Now, this was familiar language. The Civil Rights Act of 1866 defined citizens of the United States as, quote, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, unquote. Not subject to any foreign power. It is universally agreed that the immediate impulse for the passage of the 14th Amendment was to constitutionalize the Civil Rights Act of 1866. It was an attempt to put the question of citizenship and matters of federal civil rights beyond the reach of simple congressional majorities. Thus, it is clear the idea of allegiance, not subject to any foreign power, quote unquote, was central to understanding the jurisdiction clause of the 14th Amendment. Much of the debate about the jurisdiction clause in Congress centered on the status of Indians. The immediate question was whether the 14th Amendment would confer citizenship upon the Indians as well as upon the newly freed slaves. The former slaves, of course, had been born in the United States, had always been subject to jurisdiction. Was the same true of Indians? Indians were surely born in the United States, but were they subject to its jurisdiction in the sense of not owing allegiance to anybody else? Senator Trumbull, the chairman of the Senate Judiciary Committee, he noted that the provision that all persons born in the United States and subject to the jurisdiction thereof are citizens means subject to the complete jurisdiction thereof, unquote. He proceeded to deny that Indians were in any sense subject to complete jurisdiction of the United States. He said we make treaties with them and therefore they're not subject to our jurisdiction. It cannot be said of any Indian who owes allegiance, partial allegiance if you please, to some other government that he's subject to the jurisdiction of the United States. Now, the author of the Citizenship Clause, Senator Howard, emphatically agreed with Trumbull's assessment that Indians would not become citizens of the United States. And by the way, many of the Native Americans didn't want to become citizens of the United States. So it wasn't like they were punishing the Indians. But insofar as Indians owed tribal allegiance, they were not within the jurisdiction of the United States, even though they were born within its territorial limits and in many instances subject to its laws. And by the way, over time, that changed. And over time, that changed. And today, Native Americans are citizens of the United States as well as their tribal nations. Let's see. So it is really beyond debate that the jurisdiction clause of the 14th Amendment was intended by its framers to have independent force. Not all persons born in the geographical limits of the United States are within the jurisdiction of the United States. The legal jurisdiction of the United States. To be within the jurisdiction of the United States means to be within its political jurisdiction. Those who today advocate birthright citizenship for children of illegal aliens born into the geographic boundaries of the U.S. believe the 14th Amendment extends to these children what the framers of the 14th Amendment did not extend to Native Americans. And this is why I so fervently disagree with Judge Napolitano. The absurdity of this position that the Bush people are taking on TV, that these phony professors are taking on TV, that others who claim some knowledge beyond this truth, beyond the facts, are taking on TV is simply not true. It's simply not true. And just think about how asinine that would have been. They were trying to address the issue of freed black slaves after the Civil War. And they wanted to make it abundantly clear from state to state and as a national policy matter that they were subject to the jurisdiction of the United States. They were persons subject to the jurisdiction of the United States, and they were citizens of the United States. So all of a sudden, this argument that some illegal alien or any alien can step into the United States, claim by him or herself that now they have legal and political jurisdiction, and if they give birth to a baby in the United States, that they have conferred citizenship on their own baby, is insanity. It's insanity. And it happens in only two countries, the United States and Canada. And so we do have a Supreme Court decision, a perversion of the Supreme. By the way, I've got tons more here on this. We'll only take it step by step here. United States versus Wong Kim Ark in 1898. With the Supreme Court, as it has done so often, turned the language in the Constitution on its head. And now you're going to hear, and you have heard people say, there's no recourse. A constitutional amendment, that's not going to happen, they say. And of course, the Supreme Court's not going to reverse itself. And so, typically, move on, America, move on. The case is closed. It's all over. Watch your society deteriorate. Watch what's... There's nothing you can do about it. We're stuck. We're stuck. Just move along. No, we're not. In this particular instance, the Constitution is on our side in a second way. Article 1, Section 8 of the Constitution grants plenary power, the broadest possible power, to the United States Congress, quote, to establish the uniform rule of naturalization, unquote. And as Erler points out, by necessary inference, Congress has the power to regulate immigration and set the terms by which those who are legally admitted can remain in the country. It certainly can establish standards for which the contract of citizenship can be offered and the qualifications of those to whom it will be offered. Congress is fully competent under the 14th Amendment to pass legislation defining those who are subject to the jurisdiction of the United States. It doesn't require a constitutional amendment to withhold citizenship from children born in the United States of illegal alien parents. Their parents are not subject to the jurisdiction of the United States, the political and legal jurisdiction of the United States, and they seek citizenship for their children without the consent of the nation. It defies logic to insist that an illegal act on the part of parents can confer the boon of citizenship upon their children. The nation has specified the terms of its consent in the Uniform Rules for Naturalization and laws governing immigration. The argument for birthright citizenship is more suitable to feudalism than it is to republicanism. I will continue this issue as soon as we return. I'll be right back.
Mark Levin.